The Tigers are on the prowl, and the ACC is the prey.
The ACC lawsuits are always in the news, so we're back on the big mountain to break it down for you.
Well, Steve, we have a new lawsuit to talk about here on
always
the
and
mountain.
forever.
Oh my goodness, one that I think everybody knew was coming. They didn't know exactly when it was going to drop. Well, it dropped on Tuesday. Clemson University filing suit against the ACC in South Carolina. If you're new to the channel, I want to welcome you. I am JY, and this is my good friend Steve. We have been covering the ACC FSU lawsuits here for quite a while, and since this one just dropped, we've got to come in and talk about this one as well. So just kind of get into this real quick. If you're new, if you're a Tigers fan, again, we welcome you here. Our focus is really on the Big Ten and the Mountain West. And that's the two conferences that we cover. However, as I said, we covering the ACC issues, and before that, we covered a lot of the Pac-12 and continue to cover the Pac-12 conference and the ongoings there, especially with Washington State and Oregon State. Lastly, we've done some deep dives on the grant of rights. We've done some different items on that with talking to attorneys, reading some articles from attorneys. So if you're interested in any of that, please check out our channel. I'll put some links up here as well. You can go back if you're interested in some of that detail. We've got a lot of stuff here that we've done over the past couple months. But let's get into this hot off the press lawsuit filed by the state of South Carolina, County of Pickens, Clemson University, known as the plaintiffs here, versus the Atlantic Coast Conference as the defendant. This complaint is for a declaratory judgment action under the South Carolina Code of Laws. Let me just say that after covering the FSU case here very, very closely and the pissing match that's really become, this Clemson filing for me, Steve, was very well done. Laid out very, very well. Was an easy read. I mean, maybe easy because we've been really deep into the grant of rights documents and the ACC, but to me, it was precise. Again, well laid out. And it really just hit the points of greatest concern, to which there's going to be three, and we're going to talk about them. Clemson first starts out claiming that the ACC asserts that they own the irrevocable media rights of its members through 2036, even if that member leaves the conference. Also, the ACC claims that a member must pay an exorbitant amount in order to leave the conference. Two things that FSU is also claiming right now.
Clemson is claiming that.
What did I say?
You said the ACC.
Yes, Clemson is claiming that. I apologize.
Yeah, no.
These claims hinder Clemson's ability to explore options regarding conference membership, to negotiate alternative revenue-sharing proposals among members, and to obtain full value for their future media rights. Because of these issues, Clemson is seeking a declaration of its rights, again, to three main topics. Number one, the scope of Clemson's grant of its media rights to the conference. Item number two, the invalidity and enforceability of the exorbitant withdrawal penalty. And item number three, the non-existence of fiduciary duties that the ACC claims to owe its members. Let me get into these three a little bit more, then I want to shoot it to you, Steve. So the grant of rights here. Clemson makes it clear that their understanding to the obligation of this right is only while Clemson is a member of the conference. It does not apply to games after a school exits the conference. The contention in regard to this fact about the scope of the grant of rights must be corrected now. The withdrawal penalty. While this describes as it's described as liquidated damages or as a form of alternative performance by the ACC, the exorbitant penalties of 3 times the operating budgets, which is currently about $140 million, is not connected to the economic harm of the conference if a member were to exit. And then the fiduciary duties. The ACC has claimed recently in the FSU court filings that members owe the conference a fiduciary duty, and has gone even further and has sued another member of the conference for allegedly breaching those duties. Clemson disagrees with this assertion of fiduciary duty, and Clemson has not breached any legal duty owed to the ACC by filing this lawsuit. Clemson does not challenge the enforceability of the grant of rights, but merely seeks a judgment regarding the scope of the rights granted. And I highlighted that last sentence. They're very clear here. They're not challenging the enforceability. What they're challenging is the scope of this grant of rights. Anything you want to add to that, Steve, before we get into some more details?
Well, I'll just say, Clemson, they waited a while to do this, a lot longer than many people thought.
Yes.
And I'll say, in some ways it can be very smart. They kind of just waited to let Florida State and the ACC make their move and counter move, saw a couple moves so that they could play. And now they're going to play on like a separate chessboard against the ACC at the same time, and they know what the ACC's moves are going to be.
Absolutely.
So they can tailor. They were able to tailor this, make it more streamlined. I think there's different issues in Clemson or in the state of South Carolina versus the state of Florida. So they're going much more streamlined, trying to be a little bit more efficient, a little bit more narrow in scope. It makes it for a little more pleasant reading.
Yes.
It's way too early to tell if that's a smart strategy or not. Florida State, they kind of threw everything at the wall, wide net. We're going to take 50 shots at you and see if we can hit you with 3 of them. Whereas, Clemson appears to be so far taking 3 very, narrow, deadly target aim shots at you at the ACC. So different way of going about things. We'll see how it works out.
Yeah, and the next items I'm going to get into are really just that. And it really starts with the fiduciary duty piece. I don't think this would have come up if they would have filed first. Yep. That's being brought up because of what the ACC is saying and the lawsuit that they have against FSU now. So Clemson's saying, hey, that's not what we're trying to do here. We just want a declaration. We want an action as to what the scope of this document truly means. Again, whether or not that plays or not, I don't think it will with the ACC. We see what they're doing with FSU, but I get why they're doing it. The other things they're going to talk about, I'm going to get into these in more detail, a controversy exists. That sounds like the FSU argument. Yep. They're going to talk about who the parties actually are. That sounds like the FSU pissing match we've had. They're going to talk about jurisdiction and venue. That sounds like the pissing match from Florida. They're going to talk about the grant of rights agreements and more detail in terms of what they are or what they aren't. They're going to talk about the ESPN agreements and what do they say. And they actually have items in this, I'll get into this, that are completely redacted from the public view. Several pages that are just completely blacked out because they're referencing more so the ESPN agreements, and they're being careful with that. Where FSU just went, bam, here it is. Like, we don't give a crap. We want it all. So they are definitely being more cautious. Again, I don't know if that's going to be a pro or a con. I can tell you reading this, very impressive, though.
Can I offer a quick theory about that?
Go for it.
Okay. So my theory, I've said for a while that I think Florida State, I have 2 theories on it. Okay. Florida State is more than willing, Florida State University and their board is more than willing to drag ESPN into this battle.
Yes.
For a couple different reasons. I think because I think they would love to see this, and I've mentioned this a few times, and I'm still a little puzzled why it hasn't happened yet.
Sure.
They'd love to see this turn into a battle of DeSantis, the governor of Florida, versus Disney, the parent company of ESPN. That would help them immensely, I think. And here's this is just kind of my, Steve's thought of the day on this. As soon as I read this and saw what was included, what was not included. Yeah. I have said for a while, I believe Florida State will be a member of the Big Ten here soon in the next few years. Big Ten is under the Fox umbrella. I think the most logical landing place, none of my contacts in the Big Ten have said anything about Clemson coming to the Big Ten. And honestly, I think Clemson, just their style, their brand, they're probably a more natural fit with the SEC. SEC is under that ESPN umbrella, so they don't want to piss off ESPN when they're hoping to join the SEC and get that nice ESPN payday. So that's just my kind of theory on some of this. And there are probably some other reasons, but I think those two things may have factored into this.
I love that theory. I think it makes complete sense. And their items 1 and 2 speak to the two main reasons. Again, going back to episodes we've done as we've really gotten into detail on the grant of rights and the potential challenges to a grant of rights and how you can get out of a conference. Again, number 1, the scope is what they need to know. When can we get out?
Yep.
And the validity of the withdrawal penalty, both regarding the ACC Constitution and regarding if there's a penalty in the grant of rights. They're pretty specific that they're talking about the Constitution penalties here, at least for now. But they are definitely taking the step back, letting FSU take all the bullets or most of the bullets. We're going to ride in and come in behind, and we really just need these answers to these two questions. The fiduciary duty piece, to me, is just them protecting themselves after they saw what happened to FSU here. I don't think that's not something that's going to change their minds about leaving the ACC. They're just trying to protect something that they see maybe is problematic for FSU. I don't know. So let's get into... A controversy exists, and we've talked about this with the FSU. This one I always scratched my head with the FSU. But here they get into, they say right off the bat, there are some areas in this filing. There's some redacted areas in this filing here, but this is the correct way to do these things and the most risk-adverse way to do these things against the ACC to file suit against Clemson is to have some of these areas redacted. Again, you got to be a little... If you want to, what's the easier way to catch a bear with honey or whatever? Yeah, exactly. Yeah. So, maybe they're doing a little bit of that right now. Flies with honey, that's it. Also, I think it's very interesting... as one of the counters to the FSU is using, again, in their motion to dismiss, that there is no controversy. So they're talking about whether or not there's a controversy here. The controversy here, according to Clemson, is over the withdrawal penalties and the scope of the grant of rights. Without a judicial declaration, Clemson is unable to pursue a wide range of strategic alternatives that may be necessary for its continued success in collegiate athletics. Further, the prospect that Clemson might be subject to claims that it breached these non-existent fiduciary duties requires a declaration as to the existence of such duties. They then get into parties. Clemson is a public institution of higher education in South Carolina. The ACC is an unincorporated nonprofit association with 15 members, where its principal place of business, obviously, is in North Carolina. Jurisdiction and venue. The South Carolina court has subject matter jurisdiction over this dispute and has general and specific personal jurisdiction over the parties. The ACC is subject to this jurisdiction due to the facts that 1, the ACC has transacted business in South Carolina. 2, the ACC has entered into contracts to be formed in part by Clemson University. And 3, the ACC has committed an act outside of South Carolina causing wrongful injuries in a South Carolina venue, which is appropriate Pickens County, South Carolina, because the most substantial acts and omissions that gave rise to this action occurred in Pickens County. They then go into the current state of college sports and the revenue gap. And they get into a lot of detail here. It's several pages long. Really, it's just talking about, I think it's 10 paragraphs, several pages. They're just talking about the growing gap between the SEC and the Big Ten and the lucrative media contracts that they're getting and have right now. And the gap that they have to deal with that continues to grow larger as part of the ACC. So the next piece I want to get into is the grant of rights and the ESPN agreements. Anything you want to add here to this, Steve?
Just say real quick, I think it's just important to note, even there are some differences between how Clemson and Florida State are run.
Yeah.
So that, there's differences between states, but Clemson is, I believe it's a land-grant university, more similar to a Penn State or a Michigan State. And it is a public university, so I think that really goes into the arguments of jurisdiction, and then they make a great point, doing business in the state of South Carolina. We saw that over in Florida, doing business in the state of Florida with 2 universities, one public and one private.
Yep.
So it's just kind of, again, just putting some more stones in that wall.
Yep, for sure. So let's get into the grant of rights. The ACC is party to 2 contracts with ESPN. And I like how they laid this out. I didn't think FSU did a good job initially of laying this out. But there's 2 contracts with ESPN. One is the multimedia agreement, which is just broadcasting the games, the sports games. The second is the network agreement. That's the ACC Prestige Network. Yeah. So those are the 2. After the multimedia agreement was adopted in 2013, the members executed the grant of rights. This agreement is expressly and extrinably tied to the ESPN agreements. These documents must be read together, and they are not, as the ACC claims, a blanket grant of rights. They are explicitly limited to the ESPN agreements. While the grant of rights have been made public, the ESPN agreements have not. As a result, there is a secrecy surrounding the ESPN agreements, which restricts the members to fully understand what is being conveyed to the ACC. Here's the next part. I've highlighted this. I found this part probably to be the second most important part of what I read. The ACC has taken an incorrect position in recent court filings that claims the grant of rights does not permit withdrawal because media rights remain with the ACC even after a member institution leaves. Also, incorrect narratives about the terms, specifically that Clemson has granted the ACC full media rights through 2036, have been incorrectly repeated in the media. This inaccurate description causes an appearance to other conferences and third parties that Clemson cannot break this grant of rights before 2036, even if Clemson leaves the ACC prior to this date. I found that to be a perfect 2-3 sentence summary of why they're asking for this. That's why this is so important to them. They then go on to say, what does the ESP agreements say? Again, there's about 2.5 pages of just blacked out, redacted information in this claim. This for now is protected information, and props to Clemson for doing this. We didn't see this in the FSU filing, which is causing some issues. We have another FSU episode coming out tomorrow, and they kind of get into that a little bit. Further in this, Clemson points out that the ACC has misconstrued the grant of rights, again, as a blanket grant of its media rights for the entire term of the grant of rights. When construed with ESPN agreements, the grant of right permits the rights to be rebroadcast of past games while its members are no longer with the ACC, even if Clemson then departs, meaning the games from this past year are owned by ESPN and the ACC. Clemson fully understands that. They're not asking to take those with them. Yeah, we were with you. We got money for those. You own them. And they aren't disputing that. However, the obligations under the ESPN agreements do not convey any rights to the ACC if Clemson was no longer a member, aka moving forward. They then go on to talk about the unenforceability and withdrawal penalty. The withdrawal penalty has no relationship to and they say, fact plainly disproportionate to, the actual damage that would flow from Clemson leaving the ACC. While the Constitution refers to these as liquidated damages, these are actually a penalty and they are unenforceable. This withdrawal penalty was not a predetermined measure of compensation for actual damages. Rather, it was adopted as punitive measures aimed at discouraging and preventing member institutions from withdrawing. Clemson then questions if the ACC would suffer any damages if they were to withdraw. They go on to point out that the ACC has the most excessive penalties of any of the Power 4 conferences. They finally then summarize their cause of actions and prayers of relief. Again, cause of action number 1, the grant of right only applies when Clemson is a member of the ACC. Action number 2, the withdrawal penalty should be declared void and unenforceable, as Clemson is not required to pay it. And the third action, this one being the non-existent fiduciary duties, Clemson does not owe any fiduciary duties to the ACC, nor does filing this lawsuit breach any legal duty. Also, under the prayers of relief, the request award for the cost of it, or they request an award for the cost of this action and any other awards that the court deems necessary. So I threw that all there at the end, Steve. What are your thoughts?
So I would just say, kind of continue with the line of thinking that, Clemson, they were smart. They waited their time. They were able to basically use, the Florida State lawsuit as a rough draft, as a first version.
Yep.
And they've created a more just kind of nuanced approach that's a little more targeted in certain areas.
Yes.
Now, what I'll say is they can do that because I think a lot of this stuff, they're going with lower risk. Florida State went boldly into this, high risk, high reward. They're just throwing everything out on the table. And we'll see, we'll let the cards land where they may.
Yeah.
And Clemson, they don't have to do that. Florida State's already fighting the battle to get that grant of rights in the public record.
Right.
They're already fighting a lot of these battles, whereas Clemson can come in smartly and take a more nuanced approach and do this, keep it more limited, and they are limiting their risk. They're not taking a big risk with this, as much of a risk. They're more saying, we're not challenging this. We just want, a court to weigh in to define the limits of this and tell us what's enforceable and what's not, so that we can better operate within the market space, which is smart.
Yeah.
But again, Florida State kind of had to walk through that wall so that Clemson could run.
Yes.
And I think it's smart for them to do. I'm just interested to see how it's going to play out. Now, another thing I will add, in our Florida State video, I talked about the pressure game.
Yeah.
It's a pressure game, move, counter move. You're trying to put pressure on the other side to hopefully get them in a position to where it's not worth the fight anymore. Let's just settle. Mm-hmm. This is kind of, we're opening up a new front. If you have World War II and Germany's trying to fight Russia on one side and United States on the other side.
Yeah.
So we're opening another front. We have another state. And so, maybe Florida State's taking that full, frontal assault kind of thing, and Clemson's just doing a little bit of a side knife,
right.
Shanking them in the side. Which again I think is smart. So it's really going to be interesting to see how the ACC responds.
Yeah.
They made some really good streamlined points about venue, about jurisdiction, and really I think they learned a lot of lessons from the Florida State suit. What's happened so far?
Answering the questions that the ACC was going to ask anyway. We're just going to put it out there. Don't ask them again. The one piece I found to be really interesting, and we'll wrap this up, was when they get into the withdrawal penalties, and they hit the nail on the head, whether they're talking liquidated damages. They aren't, the cost of us leaving. These are arbitrary or punitive measures, which is exactly what they were. They're punitive measures, 100% about that. But when they go on, the only time I went, oh, you went a little too far for me here, is when they say, Clemson then questions if the ACC would suffer any damages if they were to withdraw. Oh, that one was a little tough for me. Of course there's going to be some damages. You're one of the biggest schools in the ACC, for crying out loud. But I get it. It's from their side.
I think it's a smart thing to throw that, to question, okay, would they? Well, how much would the actual, because their point of view is that the penalties are punitive and not aligned with what they would actually lose. So if ACC pushes back against that, okay, well, let's do some kind of a market study and see what you would lose. Which again just enters that into the case, and where a judge could say, you know what, it makes a lot more sense for you to pay something closer to what you would actually lose than these unnecessarily punitive measures that were. We did that grant of rights episode. The whole point of this was to bar the doors and not let anybody out.
That's right. Again, and I'm going to go back to something I said a while back in some of the FSUs. When you start with a negotiation, you want to start you don't want to start. The two sides start as far apart as they can. So that right there tells me Clemson's starting at 0. Yeah. They want to start at 0, and of course the ACC's at that. What is it? Half a billion dollars or whatever.
Almost,
so they're way far apart. But that kind of gives you the answer. If Clemson's on the 0 line, and you know, they'll move if they have to, right? So,
and if it moves at all, they've won.
It's absolutely, yeah, exactly. So, hey, with that, our first episode on the Clemson Tigers. It won't be our last. I think actually the ACC responded as we're typing or as we're recording this today, so we'll get an update on that next week for sure. And again, if you're new to the channel, we don't do breaking news. We read these documents. We read all of these verbatim, word for word. We digest, and then we spit them back out, giving our opinions on these. Just want to make sure people, if they're new to the channel, they don't think we're going to get breaking news from us. You're going to get it from us. It'll be slightly delayed. So, hey, with that, if you like this episode, make sure you give it a thumbs up and a like. Subscribe if you like our content. And with that, we'll see you guys next time on the Big Mountain.